that is right to constitutional remedies. In Article 32, we discussed about 4 clauses, whose second clause says that Supreme Court has power to issue directions, orders or writs against the violator for the violation of fundamental right. So today we will be discussing about the same writ and types of writ in detail. Well, as we already know, power to issue writ rests with the Supreme Court as well as the High Court. First of all, we have to understand what is writ and from where we have taken this provision. Well, writ is a legal written order issued by Supreme Court under Article 32 and High Court under Article 226 for the violation of fundamental rights. This provision has been taken from the British Constitution. This is simple and general definition of writ. Let's understand this in detail. So far, we have discussed many times that Part 3 of the Indian Constitution has given us a lot of rights. But what is the value of these rights if there is no one to protect them? There is no one to take guarantee on their violation. There should be someone who can take guarantee, otherwise what is the point of giving so many rights? Therefore, the Constitution of India has called Supreme Court the guarantor of fundamental rights and has given an extraordinary power to issue writ in order to enforce the fundamental right if violated. So, writ is that legal order which is issued by Supreme Court and High Court. But if needed, Parliament can empower other courts also to issue writ. Now the question is, who can file a writ petition? Basically, 2 types of person can file a writ petition. Number 1, any person whose own fundamental right has been violated by the state. Such person is called a aggrieved person. And another person whose own fundamental right has not been violated, but that person can file a writ petition for the interest of general public. Like any group of people that is in disadvantage, such person is called public spirited person. So this person can be any individual or any organization or NGO, etc. One more thing you should note down, that a person from this group can also file a writ petition in the court. This type of petition is called representative petition, where a person seeks justice for himself as well as for his group. Now another question is, against whom the writ petition can be filed? The answer is that writ petition can only be filed against state or bodies that comes under the definition of state. Now for this you have to go through Article 12, in which the definition of state has been talked about. For now, we will take some examples to understand what comes under the definition of state. For example, central government and parliament, state government and state legislature, local authorities like municipalities, municipal corporation, Nagar Palika, Zilla Panchayat, statutory and non-statutory bodies like National Human Rights Commission, Central Bureau of Investigation, government or semi-government institutions, or institutions which are fully or partially funded by government, etc. These are the major examples of state and bodies which comes under the definition of state. So in short, writ is a legal written order issued by Supreme Court or High Court against the state or authority of state for the violation of fundamental rights. Now the third question is, where can a writ petition be filed? As we have already discussed, writ petition can be filed in the Supreme Court and the High Court. Supreme Court has got this power under Article 32 and High Court has got this power under Article 226 of the Indian Constitution. Right to move the Supreme Court in case of violation of a fundamental right is in itself a fundamental right, since it is contained in Part 3 of the Indian Constitution. Apart from these 2 courts, Parliament can empower other courts also to issue writ. But as of now, the Parliament has not given any other courts the power to issue a writ. But if ever needed, it can be done. Now, writ issued by the Supreme Court or High Court can be of different nature, or you can say that of different types. So the types of writ are Habeas Corpus, Mandamus, Quo-Warranto, Certiorari and Prohibition. These writs are issued in different situations and circumstances. Now we will understand each one of these one by one. The first type of writ is Habeas Corpus, which means to have the body of. The writ of habeas corpus is issued by the court when there is an unlawful detention of a person by any public authority or private individual. Public authority are those who perform governmental works, and private individuals are those who do not belong to any group, company or organization. Now this person who has been detained unlawfully or illegally can file a writ of habeas corpus in the court against the authority who has detained him. On behalf of this person, his family can also file a writ of habeas corpus in the court. Now in such situation, court asks to have the body of the person who has been detained. This means the court asks to produce the person before the court. When the person is produced, the court questions the detaining authority what were the reasons for detaining this person. If the reasons are found valid by the court, then writ will not be issued against the detaining authority. But if the reasons are found invalid by the court, then writ will be issued against the detaining authority and action will be taken. And the detained person will be set free. After that, the person can also claim for the compensation. Second type of writ is mandamus, which means we command. Writ of mandamus is issued by the court to direct a public authority to perform the legal duties obliged under law to do, which it has failed to perform or refused to perform. Under this comes central or state government, public officials, public corporations, inferior courts, etc. Writ of mandamus cannot be issued against any private individual, the President of India, or the state governors and the Chief Justice of High Court. Now let's take an example to understand that when a writ of mandamus can be filed. We took this example in the last video as well, where we saw that a boy applies to take admission in a college, which is a government college, and the authority of that college refuses to take admission just because the boy belongs to a different caste or maybe a different religion. In such situation, the boy can file a writ of mandamus in the court against this institution. After that, court can take action against this institution. Now suppose this college has a discretionary power whether it want to take admission or not. Like there are some institutions who take admission on the reservation basis, means it is not mandatory to take admission. So in such situation, writ of mandamus cannot be issued. The third type of writ is writ of Quo-Warranto, which means by what warrant or by what authority. The writ of Quo-Warranto is issued by the court against a person who holds a public office unlawfully. Public office means anything which performs a governmental work or which is for the general public or which is established by law or any elected person. If such person administrate any public office unlawfully or the person is not authorized to hold that office, then court can issue writ of Quo-Warranto against the person and can remove that person from his position. This writ cannot be issued against any private office. Let's take an example to understand when a writ of Quo-Warranto can be issued. Suppose a person is appointed as a judge of a high court, and later it was found out that judge is not qualified enough for that position, and yet he remains at the same position. In such situation, writ of Quo-Warranto can be issued by the court against that judge and can be removed from his position. Now the next writ is writ of Certiorari, which means to be certified. Writ of Certiorari is issued by the Supreme Court or High Court to the lower courts to transfer the matter to it for the proper further processing. Or it can also be issued by Supreme Court or High Court for quashing the order already passed by the lower courts. Quashing the order means cancelling the order given by the lower court. This happens when the lower courts acts beyond the limits of its power or makes mistakes while giving the judgment. In such situation, writ of certiorari can be issued by the higher courts to its lower courts. Let's take an example to understand this. Suppose there is a dispute between Ram and Shyam for a land. This land is in District A. Ram registers a case in District A, and at the same time Shyam also registers a case in his own district, that is District B. If District Court of B gives its judgment in this matter, will that be right? No, it doesn't come under its jurisdiction and will also create a confusion. In such situation, higher court can issue a writ of certiorari against the lower court asking that are you certified to take that decision? And also the higher court can transfer the case to itself for further processing. Now moving to the last writ, that is writ of prohibition, which means to stop. Writ of prohibition is actually similar to writ of certiorari. It is issued by the same authority and is issued against the same authority. Means it is issued by the High Court or Supreme Court to its lower courts. The only difference is the stage at which they are issued. Writ of certiorari is issued after the case is heard and decided. It is issued to cancel the decision of the lower court, whereas the writ of prohibition is issued while the proceeding of a case is going on. If the higher court finds in the mid of the proceeding that the lower court is acting outside its jurisdiction, in such situation, higher court, that is Supreme Court or High Court, can issue a writ of prohibition to stop the proceeding of the case. As we saw in the previous example about the land dispute, if Shyam appeals to the higher court in the middle of the proceeding, then the higher court can issue writ of prohibition to stop the proceeding. So that's all about writ and types of writ. In the next video, we will discuss about Article 33, that is Armed Forces and Fundamental Rights.